Okay, recalling number 28 on the docket, 23 CR 5359, People versus Thurl Quick.
Kelsey Madden, Kevin Wharton for the people.
Your Honor, Chris Braddock appearing with Mr. Quick. He's present.
Okay, and we do have our court reporter for reporting. My understanding, Mr. Quick, from our conversation this morning, that you are asking to proceed pro se for purposes of sentencing. Is that correct?
Yes, Your Honor.
And you've gone over the advisement right to counsel prepared by the district attorney. Is that correct?
Yes, ma'am.
All right. Before I release Mr. Braddock and allow you to proceed pro se, I want to go over this with you on the record, okay?
Ma'am.
So before accepting your decision to waive representation by counsel and allow you to proceed pro se, you're hereby advised that you have a constitutional right to self-representation under the United States and Colorado constitutions. Do you understand that?
Yes, Your Honor.
Do you understand that you have the right to be represented throughout these proceedings?
Yes, ma'am.
Do you understand that if you cannot afford an attorney, one will be provided to you free of charge? And indeed, in this case, you have one free of charge. Mr. Braddock has been appointed as ADC. Is that accurate?
Yes, ma'am.
And you understand that?
Yes, ma'am.
Do you understand that I will continue his representation and his appointment of counsel if you want to be represented by counsel?
Yes, ma'am. I understand that.
And based on the charges for which you've been convicted, that is unlawful possession of a controlled substance with the special offender, which means that your conviction is for a drug felony 1, underlying factual basis of a drug felony 4. Do you understand that?
Yes, ma'am.
Do you understand because of that conviction, you're looking at a mandatory sentence to the Department of Corrections between 8 and 32 years?
Yes, ma'am.
To be followed by 3 years of parole, which is served after consecutive to the carceral portion of that sentence.
Yes, ma'am.
You understand you're looking at a fine of between $5,000 and $1 million,
Yes, ma'am.
and that there is a drug offender surcharge of $4,500. Do you understand that?
Yes, Your Honor.
There are some additional statutory fees and costs that the court may impose as well. Do you understand that?
Yes, ma'am.
How far did you go in school?
GED.
And some college, is that accurate?
Yes, ma'am.
Hey guys, welcome back to today's video. This time, we've got a defendant facing sentencing after being convicted of cocaine possession and illegally possessing a firearm, and things only get worse from there. This isn't his first run-in with the law either. He's already a 4-time convicted felon, which means the consequences are about to hit a whole lot harder. After dragging out his sentencing for as long as possible, he's finally running out of road, especially with an 8-year mandatory prison sentence hanging over his head. But instead of accepting reality, he decides to fire up the chaos by representing himself in court, convinced his attorney isn't on his side simply because the lawyer refuses to file pointless motions just to stall the inevitable. So, with that disaster brewing, let's get into it.
Suppose I need to ask, sir, you're here for sentencing. Are you going to be prepared to proceed to sentencing?
No, Your Honor. I was going to ask for time to prepare.
Mr. Braddock, were you otherwise prepared for sentencing?
Yes, Your Honor. I was prepared to go to sentencing today, but Mr. Quick, we haven't, I don't know if he has a copy of the PSI. I know he has reviewed it, but it has been quite some time since he has reviewed it. I want to say back in November. We originally were set for sentencing, and at that time, he wanted to retain private counsel. So I do know it's been probably 2 months or so since we have spoken about the sentencing today.
Okay. That's my memory as well. Mr. Quick, you had indicated that you were looking to hire counsel both for purposes of sentencing and or for purposes of filing the appeal in this case. My memory is that I indicated to you on the last court date that I would consider your last motion to continue to hire counsel for purposes of sentencing, that I was not inclined to continue the matter for entry of counsel for purposes of appeal, as that can be done at a later time. Is that your memory as well?
Yes, ma'am.
I suppose I need to just sort of ask bluntly, is your request to proceed pro se based on a request to continue the sentencing in this matter?
Yes, ma'am. Oh, you say that one more time, Your Honor.
Well, I need to know, like, Mr.
No.
Braddock was prepared to proceed to sentencing today. I'm not hold on.
Oh, sorry.
I'm not promising you that if I allow you to proceed pro se, that I will again continue your sentencing
Yes,
because it
ma'am.
has been some time.
Mhm.
Knowing that I haven't made a determination on whether or not I will continue your sentencing, is it still your request to proceed pro se?
Let me think here. Because me and Mr. Braddock, it's not what we have going on right now. It doesn't have a issue with the continuance. The issue that me and Mr. Braddock is having is we're not seeing eye to eye on motion. So this is a situation where me and him aren't able to come to an agreement. So we're having a conflict of interest. That's what brought this about today.
What motions are you not seeing eye to eye on?
There's a motion that we both were talking about, and we just couldn't see eye to eye on the filing of the motion. And then when it came to the private counsel, I was almost able to, I've almost been able to get private counsel, but I'm still short, Your Honor. I'm still short a few $1,000s. So that's the conflicts that we were having in the situation.
Well, whether you can retain counsel or not is not a conflict between you and Mr. Braddock. So
Oh, no, me and Mr. Braddock was, we had, I want to have control over filing motions, and that's the problem that we're having. If I go pro se, then I'll be able to file the motions that that we're not seeing eye to eye on.
what motions are those?
The motion that we weren't seeing eye to eye on was I wanted to ask you for a motion to stay execution of sentence today, once I went pro se.
Well, I know that.
Yes.
But what I'm telling you right now is that I'm not promising you that I'll do that. That's essentially a request to again continue your sentencing hearing.
Yes, Your Honor.
So Mr. Braddock, whether it's you or Mr. Braddock, there's a request to continue the sentencing. I have to make a finding whether there's good cause. It doesn't matter who files it.
Mm-hmm.
So if your request, if for example, you're asserting a conflict with your current counsel that would warrant or necessitate appointment of alternate defense counsel, that's a determination I have to make on whether there's a conflict.
Mm-hmm.
You didn't raise that issue before. You just simply said that you wanted to proceed pro se. And I suppose my concern is you're asking to proceed pro se just so you can ask to continue.
No, Your Honor. I'm asking, I'm not asking pro se just to continue. No, that's not the reason why I'm asking to go pro se. The reason why I'm asking to go pro se is because I would like to maintain all my rights to file my own motions.
But what motions are you wanting to file?
I was going to file the let me see here. Okay, I have a few different motions here, so, Your Honor, that I was going over. But today I was actually going to file a motion. It looks like that this motion right here, I was going to a verified amended motion for stay of execution, assertion of due process and confrontation clause violations.
Stay of execution of what?
Stay of execution, assertion of due process and confrontation clause violations.
What is the due process violation that you're asserting?
The due process violation that I'm asserting on this one is more dedicated towards a new trial. under my constitutional rights violations. So this is more of trying to get a new headed towards a new trial with this motion. So I'm just asking time to file the motion because I'm trying to pursue getting a new trial.
Oh, you got a GED and some college? Well, that changes everything. You probably should have led with that since it apparently qualifies you to be the greatest legal mind in the courtroom, especially when paired with your lucky court hoodie. And hey, maybe the cocaine sales were just a creative scholarship fund to pay off some college debt.
Okay. So you're asking to proceed pro se so that you can file a motion for new
For a
trial.
new trial, yes, ma'am, under procedural violations and constitutional violations, yes, Your Honor.
Is this the motion you've discussed with Mr. Braddock that he has declined to file should he continue to represent you?
Yes, Your Honor. This is what we weren't seeing eye to eye on.
Okay. So let me just make sure we're not talking about a conflict issue. Mr. Braddock, you've made a determination. Well, I don't want to put words in your mouth. What determination have you made regarding the merits of a motion for new trial?
Your Honor, I have spoken briefly to Mr. Quick regarding this, and I declined to file a motion.
Okay. So, Mr. Quick, ultimately, when you're represented by counsel, it's your counsel's determination on whether or not any particular motion, including a motion for new trial, they have to make a determination on whether it can be filed based on the merits and their assessment of the issues and factual circumstances of the case. A decision by counsel not to file that motion or any sort of motion like that is a strategic decision that is within counsel's purview to make. So I would not find that there is a conflict that would warrant appointment of alternate defense counsel other than Mr. Braddock. So, and you haven't said this, but to the extent that there is a request based on a conflict that you may or may not be asserting, I would find that there is no conflict. So you can proceed with Mr. Braddock, knowing that he's made the determination that motion will not be filed, or coming back to the determination on whether you want to proceed pro se. Is it still your request to proceed pro se in this matter?
Yes, Your Honor, I would like to proceed pro se, and I would ask if you would give me time to file my motions.
Let me ask the people, any additional record on the conflict that is quasi-asserted and or record or any requests for additional findings on the request to proceed pro se?
No, nothing from people.
All right, based on what I've heard today and the advisement I've given, I will grant Mr. Quick's request to proceed pro se. Mr. Braddock, you are withdrawn as counsel. I'm going to sign the advisement of right to counsel indicating that I went over this with you and my ultimate findings. That Mr. Quick's decision to proceed pro se is knowing, voluntary, and intelligent. Copy of the advisement will be placed in the court record. Okay, turning to Mr. Quick's request to continue for time to file a motion for new trial, what's the people's position?
At this point, I'm objecting to the motion to continue. As the court has noted, that can be filed later. At this point, there's been quite a bit of time since trial. This was in September. We had sentencing in November. There's been plenty of time to prepare for sentencing. And at this point, I'm so sorry. There's been plenty of time to proceed to prepare for sentencing. At this point, I am asking that we go forward on the sentence.
Okay. I am reluctant to do this, but I'm going to grant the request to continue the sentencing in this matter.
Thank you.
I'm going
so
to
much, Your Honor.
put this on a tight deadline. Mr. Quick, you have 7 days to file that motion.
Yes, ma'am.
Any motions.
Yes, ma'am.
The people have 14 days to file any response to any motions. I'm going to reset the matter for sentencing. Mr. Quick, you need to plan to proceed to sentencing on the next court date in the event that any of the motions that you file are granted that would obviate or get rid of any need to continue to sentencing. We'll address it at that time, but you otherwise need to be prepared for sentencing. Do you understand?
Yes, Your Honor.
So, you didn't like the outcome of your first trial, and now you want a new one. Typical behavior.
Mr. Quick, you've appeared.
Yes, Your Honor. I apologize for my tardiness. I had a medical family emergency. I am moving for a stay of proceedings or a continuance today. As of yesterday, I filed a lawsuit over in Arapahoe District Court. I'm still having to gain a whole lot of evidence and everything in that case, and just found out a whole lot that was going on. This is regarding misconduct over there that landed me in 24-hour lockup, 8 hours in isolation. I was roughed up, and I had to take emergency proceedings over there to get started over here. And I needed to get down here this morning and try to file emergency motions over here before the proceedings this morning. And I wasn't able to make it down here because a week and a half ago, on top of me building my case right now, my fiance was rushed into the emergency surgery with she had an umbilical hernia. So then she gets scheduled for the doctor this morning for emergency to come in to make sure that she can come down and help me to be here for the proceedings, because she's not supposed to be lifting over 10 pounds. So the only reason why I made that request before you today is because I did put in motions before coming up here. So I didn't know if the court would need time to consider my motions that I've put in today, or if the court, I'm not sure.
Let me see if I'm understanding you. You're asking to continue your sentencing?
Yes, Your Honor. I was just letting you know that I stopped down before coming up here today and putting in emergency motions. So I'm not sure if
Well, let me just make sure I'm understanding. You're asking to continue your sentencing because you filed a lawsuit in Arapahoe?
Oh, no, ma'am. No, Your Honor. I'm speaking for why I'm tardy on putting in my motions before coming up. So
I thought you were tardy because of a medical family emergency.
yes, ma'am. I'm late because of the medical emergency, but I'm late with my putting in my motion. I had to put in my motion this morning due to the litigation in Arapahoe that I had to take care of before coming over for sentencing today. Just in case we move forward with sentencing, I had to make sure that everything was covered on those bases if I was to go into custody. So that's
What's the basis that you're asking to continue?
I'm asking, well, the only basis that I'm asking to continue is for that I filed late minute motions. So I'm not sure if the court accepts my late minute motions or.
I don't know what they are because when
Okay.
you file them in the clerk's office, obviously they're not immediately put into the record.
Oh, okay. Yes, ma'am. See, I wasn't aware of that, Your Honor. I thought once he filed them in the computer, they came right up to you. I thought you could already see.
He filed to
On
give
your
me a written copy. I've already scanned it if you'd like the written copy I have.
Yes, thank you. So the motion is motion for appeal bond and stay of execution pending appeal.
Yes, Your Honor.
And then it looks like you filed a notice of appeal.
Yes, Your Honor.
Spoiler alert, he was not prepared. He rolled into sentencing late, armed with a million irrelevant excuses and apparently a family-sized bowl of breakfast crayons for emotional support.
As soon as it's dependent on the outcome of the sentencing. So if I'm sentenced today, it'll be filed today with Supreme Court, and as soon as we get a case number basically for the
Okay,
appeal case.
so it's pending,
Yes.
or it'll be filed after your sentencing?
Yes, ma'am.
Okay,
And for the record, Your Honor, I'd already motioned prior to this, alerting the court that I was going to, of everything that would be taking place today. But just like I said, I got so caught up in my personal life that I got backed up on getting all my paperwork over.
I'm sorry, there's an additional motion?
No, ma'am, you've already looked over the motion, and this was in the motions that you've already answered. This is the motion that didn't get answered. That was the handwritten motion. That was to make you aware of today that I will be filing these motions that I was, let me see here. Let me get you the exact document number. I brought in the copy of it. So I filed an emergency appellate notice for the record, and it was handwritten.
You filed that in.
Yes, Your Honor, you answered on this motion right here. And this was the motion that I put in to let you know that I would be filing these motions that I filed today.
Okay, so, but that doesn't require any action.
Yes, ma'am, that's the one that you said doesn't require any action. Yes, Your Honor.
Okay, so all of your prior motions have been ruled on, correct?
Yes, ma'am.
And then this morning, you filed a motion for appeal bond and stay of execution. And then you're intending, if we proceed to sentencing, to file the notice of appeal, which you've also filed.
Yes, Your Honor, and I also filed a consent of surety from my bondsman for an appellate case.
Okay.
She agrees to stay on the bond.
What's the people's position on the request for appeal bond and stay of execution?
At this point, there's been quite a bit of time. He's still able to appeal post-sentencing. At this point, I am objecting and asking to go forward with sentencing today.
At this time, Your Honor, I'm appealing this conviction based on a juror oath and suppressed evidence. Furthermore, I am preserving all other constitutional, procedure, and jurisdictional errors occurred during this trial, including those to be identified by appellate counsel upon a full review of the record. And at this time, Your Honor, I just ask that you review my motion, and I ask that you decide based on the information that's in the facts that's in the statement already, that's written into the statement. And that's really all I can do. Just ask you to review my motions. And
You know, there are reasons people tell you not to go pro-SE. One of them is the very real risk of filing motions that can't even be ruled on yet, like trying to appeal a sentence before you've actually been sentenced.
All right, Mr. Quick, I've considered your motion. I've read it. I'm just going to tell you, I'm going to deny your request for a stay and to grant a bond pending appeal in this case. The determination on whether to grant an appeal bond is discretionary. You've had notice, I've given you multiple continuances of the sentencing in this matter to prepare. You've known for quite some time that this was a mandatory Department of Correction sentence. My prior orders have made very clear that the issues that you potentially want to raise will need to be raised in an appeal. We'll talk a little bit more for purposes of sentencing, but you were convicted of a DF1 involving possession of a firearm. This is, as far as I can tell, your fourth felony conviction. It's a mandatory DOC sentence.
Yes, Your Honor.
So I'm going to
but
deny your
under-
request. I'm denying your request.
Okay, Your Honor, all I would ask, Your Honor, in response to you denying my request is, all I would ask is if, see here, I just ask that you put your, for the record, once again, I'm just asking, Your Honor, that you put your reasons for denying in writing forthwith for me, the reason why I was denied bond, because I understand that I asked to continue it if you needed time to look over my motions. But at this time, Your Honor, for the record, I'm not clear why I'm being denied a bond, an appellate bond, even though I'm required to request an appellate bond. I'm not sure why I'm being denied, because I don't see the
Required to request an appellate bond.
Mhm.
That's a request you made.
Yes, Your Honor.
Via a motion that you filed this morning
Mm-hmm.
that I've received a copy of and which I've reviewed.
Mm-hmm.
I've said it's discretionary whether the court will grant that.
Mm-hmm.
And I stated the reasons why I was denying it.
Yes, but I'm saying, is there a legal reason why I'm being denied? Because I'm trying to figure out what a continuance has to do with my bond when I meet the two factors to have a bond in Colorado. I'm not a flight risk. I've already proven that by being free almost 3 years on my current bond. I'm not a danger to anyone in the community or anybody in the community. um, I've already showed that over the last 3 years, that I'm eligible. I'm right now, and on top of that, um, right now I'm in the process, after I get all of this done, I'm in the process of doing, let's see here, trying to pull up all my notes for you, Your Honor. Your Honor, I'm currently in the process of tracing my American Indian heritage through the Dawes role. This is a life-changing discovery for my family that requires me to remain in the community to gather records and finalize my tribal affiliation. And this just further proves, Your Honor, that I'm not a flight risk and my ties to the community. So it's not that I'm disagreeing with the decision that you're making, Your Honor. I'm just trying to get on the record an understanding of um, why it's being denied, because I I've shown already through the last 3 years that I'm not a flight risk, I'm not a danger to the community. And per your last per um per trial after trial, you're in the court's prior argument, we've already had an argument about bond, and we've already proved that in my case, deadly weapon means firearm, whether loaded or not loaded, and that's an instruction number 14. So it's not that I'm saying that I am questioning your decision. I'm just trying to give you my legal basis of my legal argument of why I think that I should be considered for a appeal bond. Because we're hearing you, Your Honor, I hear why you're saying, but I don't understand the legal grounds or the procedure why.
She doesn't need to review your motions because she might not even be the judge handling your appeal. And for starters, you haven't even been sentenced yet, genius. Filing an appeal before sentencing is like trying to leave a restaurant before your food even hits the table.
I'm not sure that I can say anything more to make you understand. I've previously said whether a court grants an appeal bond is discretionary.
Mm-hmm.
And I've given you the reasons that I'm not going to do it in this case, because I do think, given the number of prior felony convictions, the conviction in this case involving a firearm, that there are sufficient risks for your failure to appear and community safety that I'm not going to grant it.
Correct, Your Honor. But I've never missed a court. I've never missed a
Mr.
court
Quick,
date.
I'm not going to debate this. You filed your motion. I considered it. I asked if you had anything additional you wanted me to consider. I heard you out. I've repeated myself. This is not a debate. You've made your argument. I've made my ruling.
Okay. Well, um,
I don't see, you said there's a requirement for written findings. That's what I was trying to look at. Where is that?
like I told you before, Your Honor, I had already alerted the court before that I would be filing these emergency motions. May I approach?
No, I've already ruled on those. You said there's a Colorado appellate rule that requires I make written findings. Where is that?
Oh, that is this is under emergency filing checklist. This is the judge's written order. And it's just asking you for a reason for denying the bond in writing forthwith, and it's as required by C-A-R-9. Is that a semicolon? Or
Oh, sub B.
Sub B.
Okay. Colorado Appellate Rule 9 gives the reviewing appellate court authority to review any appeal bond orders and allows the appellate court to enter orders regarding a bond after review under subsection B of that rule. It doesn't require me to make specific written findings. I've made my oral findings. They're part of the record. For purposes of appeal, which is what I think you're referring to, the rules require that you include as part of the record any written orders that you might be appealing, but it doesn't require me to issue written orders or findings on this particular issue. I've stated my orders, findings and orders on the record. They are part of the record.
Okay, so is there any way that I can request a written copy, or is that your discretion also?
Yeah, I'm not going to do that. It's just writing. There's a record. You can order the transcript.
Okay, so what do we do at this point, Your Honor? Do we move on to sentencing? Because
Yes.
at this point, I object to sentencing. I've already raised the judicial errors
So
over and over again.
Sir, those, again, as I said in all of my prior written orders,
Mhm.
those issues need to be raised in the appellate court. So you can, once sentencing is finalized, you can proceed with your notice of appeal and raise all of those
Yes,
issues.
Your Honor, but with the
Mr. Quick.
oral,
Quick.
with the oral,
Quick. Those issues need to be raised in the appellate court, as I have repeatedly said in my written orders. I am not going to make a determination on whether or not the oath was given, the issues that you've raised, as I've said, those are appellate issues. You can raise those in your appeal. Is for the appeal court to decide whether I made errors and whether or not, if I did, they warrant reversal. I'm not going to continue your sentencing again, so you can re-raise the same issues that I've previously said, those are appropriate for appeal.
and
So,
and all I'm saying at this time, Your Honor, is for the record, I object to sentencing under the jury violation would take away the court's personal jurisdiction and subject matter jurisdiction. So now that you've said what I said, said that what you said for the record, I'm still raising that issue on the record that the court's jurisdiction, and I'm objecting to the sentencing, and I'm just letting you know that, and on the record for the appeal court, and request to have the public defender take over my appellate case once in custody.
You think maybe there's a reason for that? Perhaps because you're not a lawyer. I'd also wager that the attorney you fired refused to file it for the exact same reason. It was frivolous, legally baseless, and had about as much merit as arguing with a parking meter in court.
okay, your record is made. Okay, are we ready for sentencing?
People are ready.
Okay, Mr. Quick. Well, let me ask, from the people, any additions or corrections to the PSI?
No.
Mr. Quick, any additions or corrections to the PSI?
I don't have any objections to the pretty slow information.
The pre-sentence investigation report? Any additions or corrections?
Like I told you, Your Honor, I don't know anything. I don't have any objections to the pretty slow information.
I don't know what are you referring to the pre-sentence investigation report as a pretty slow information? Are we talking about the same document?
Oh, that's was my definition, Your Honor. That's what I thought it was. That's what I thought PSI meant. That was my definition. I didn't know.
No, it's the document I gave to you. It says right on it, pre-sentence investigation report.
Oh, no, I don't have that in front of me right now, Your Honor, to take a look at that. I only brought the information. I only brought documents that I thought would be relevant to the motion that I filed.
Okay, well, I advised you to be ready for sentencing. The pre-sentence investigation report is relevant for sentencing. You were previously provided a copy. Whether you brought it today or not does not matter.
Mhm.
Do you have any additions or corrections to that report that you were previously provided?
Or I didn't report it, but I didn't report it, Your Honor.
You didn't report what?
The PSI.
What do you mean you didn't report it?
Oh, maybe I'm not understanding, Your Honor. That's my definition of when you ask me, when you say reporting.
The report that was generated,
Mhm.
the pre-sentence investigation report.
Yes, Your Honor, I didn't report anything.
I'm not asking if you reported it. I'm asking if you have any additions or corrections to the information contained in the report.
No, I didn't report any additions or anything to the report. I didn't report anything.
I'm asking you today,
Mhm.
do you have any changes to this report? Is anything wrong or incorrect?
I mean, it could be wrong when reporting. I'm not sure. I didn't report anything today, Your Honor.
I'm asking you today. I know you haven't reported. You previously got a copy of the pre-sentence investigation report.
Yes, and I told you I thought that was a pretty slow. I told you what I thought it was already, Your Honor.
Whether you thought it was something else, you got a copy.
Yes, I got a copy of the pretty slow information report. Yes, and I didn't report anything. So
Okay.
you're asking me about
So
report.
I'm asking you today,
Mm-hmm.
is there any information contained in that report that is inaccurate?
I mean, it could be information contained in there that's inaccurate. I haven't reported anything on the pretty slow
Not asking you to
investigation.
reported, sir. Do you need to look at the pre-sentence investigation report?
Um,
And then you can tell me if anything's incorrect?
I mean, I can take a look at the pretty slow information, but I told you I really wouldn't understand because I didn't report anything today, Your Honor.
I'm not asking if you reported today. I'm asking if you have any changes or corrections to that document.
I mean, I see my documents here, but I don't see anything to change or report on any of my documents. And like I told you, I already looked over the pretty slow information report earlier, and I didn't have anything to report, Your Honor.
I guess it doesn't matter how many times the judge explains it. All of that comes after sentencing. And considering prison time is looking pretty unavoidable, a public defender will be assigned to handle any post-sentencing matters. So instead of stressing over that now, maybe stop stalling and face the sentencing already.
Okay.
Would you like me to print a copy for him?
No, he said he reviewed it and there's nothing to change or report. So I'll take that as no changes or corrections. It was given to him months ago. Statements by the people as to sentencing.
Yes, at this time, Your Honor, I do want to note briefly on the pretrial bond report. It did note that there was a PC warrant for a felony. It looks like that case was a no file. So at this time, this case is in the presumptive range for sentencing. The range here, the mandatory minimum is 8 years. At this point, this is his fourth felony, as the court has noted. He has a prior marijuana distribution as an F5 from 2009. Other than that, there is no other drug cases. At this point, I do believe that the mandatory minimum would be appropriate given the facts, criminal history, and the PSI. I am asking for 8 years in the Department of Corrections.
Okay. Is there restitution?
There is no restitution. No victim suffered a pecuniary loss.
And is the MPO accurate and any requests for changes?
It is accurate. No request for changes.
Okay. Mr. Quick, is there anything you would like me to know in terms of mitigation or statements of allocution for purposes of sentencing?
I just object, Your Honor. Even though that it hasn't been directly decided under Supreme Court law, but it's been looked at plenty of times, and I just still feel that it would be unfair to sentence me under where a smaller crime, a small crime was turned into a major crime. You know, that's unconstitutional, Your Honor, even though the Supreme Court hasn't answered on it, but it's still been an issue that's been raised many a times before. And to take a simple possession and then say because it was a firearm, to turn it a small possession that could have been a probationable offense or a small jail offense, and to just take it and turn it into a aggravated bigger offense. I just think that that's unconstitutional, Your Honor. And I think that that's unfair for someone who from 2009, a marijuana conviction, and now marijuana is legal in our state, you know, and to hold me liable for something that's legal now that I wouldn't even be getting in trouble for in this day and time would be harsh on the part of the court to hold that against me, you know, for I've changed my life so much since then, even though the paperwork says from 2009, but from then my life has been changed. So
Okay,
I think it's harsh
okay.
to take a petty offense and take an aggravating factor and just turn it into such a harsh punishment, Your Honor. And it's already been ruled, and it hasn't been answered in district court, but it's already been answered in federal court, and it's judge's discretion. So I would think that the same rules would apply in district court, that it would ultimately fall as your discretion on what you wanted to do in the situation after looking over all the
What is my
facts.
discretion?
The mandatory prison sentence.
Okay.
I haven't found much on it for district court besides the questions being raised about the unconstitutionality of taking a small offense and then taking an aggravating factor and then turn it into a mandatory prison sentence and turn it into a big sentence. So it's unconstitutional. And I know that in the federal court, it's judge's discretion. Like I say, I haven't found any information to back that up for the district court.
Okay. Anything further, sir?
No. Just like I said, Your Honor, before, I just want to, yes, I do have one more thing, Your Honor. Since we're on the record, if I could just get 1 second to just pull up my notes one more time, Your Honor. Like I said, like I explained to the court before, with all my family emergencies and everything going on, I wasn't fully prepared today. I just coming in because I'm going to show up. I show up to answer, and I wanted you to see that I show up regardless, even if it's hard or anything, because I wanted to prove to you today that I'm not a flight risk. And but we already addressed that issue, so I'm not gonna.
Are you saying you're not? Well, I've already issued the warrant for your arrest for failure to appear. If you're asking to continue the sentencing because you're not prepared to proceed to sentencing, I'll set it over, but I'm going to take you into custody on that FTA warrant. So do you want to proceed to sentencing today, and are you ready, or do you want to set it over?
You said you would take me in on the FTA warrant, Your Honor. Even with my records and everything, Your Honor, there's no way around that. I mean, that's why I came in and I brought record for you and everything to show.
Quick,
Okay.
I've already told you what your options are. If you want to continue your sentencing.
Yes, ma'am.
because
Yes, Your
you're
Honor.
ready,
Yes, Your
I'm
Honor.
still taking you into custody on the failure to appear warrant.
So, Your Honor, how would I pose? I think what I can say. Oh my goodness, Your Honor. Do you have a bond on that one, or?
Well, I had set a no bond hold.
I mean, Your Honor, I just don't understand why I'm being punished once again, Your Honor, for something that was out of my hand.
PSI doesn't stand for pre-sentence investigation. At this pace, it might as well mean pretty slow individual or pretty slow investigation. Not sure which one is technically right, but somehow both seem to fit.
Your Honor, I had an emergency third. Okay.
Mr. Quick.
Yes, Your Honor.
Filing motions in other counties, filing motions downstairs are not emergencies.
Oh, no, I'm saying my fiance went in for
I heard you.
Yes.
I have made very clear
Mm-hmm.
the last time we were here, in all of my written orders, you
Mm-hmm.
need to prepare for sentencing for today.
Mm-hmm.
It was clear to you today.
Yes, Your
You
Honor.
were supposed to be here at 8:30.
Yes, Your
You
Honor.
waited until 10:30
Yes,
to
Your,
find that you failed to appear.
Your Honor, you know I called, Your Honor, not to cut you
So
off.
quick, I'm not
Okay.
going to do this.
Yes,
I
ma'am.
don't need to hear any more explanations.
Okay. Can I just say, well, Your Honor, she couldn't even lift, on the doctor's order, Your Honor, she can't even lift
Mr.
10
Quick,
pounds.
I
Your
am
Honor.
not going to readdress the failure to appear.
Okay, Your Honor.
Do you want to proceed to sentencing or do you want to set your sentencing over?
Let's set the sentencing over, Your Honor, so I can have me some time to get
Okay,
prepared.
I'm going to take you into custody on the failure to appear warrant. We'll reset the matter for sentencing. I had set a no bond hold. I'm going to set bond in the amount of $25,000 cash only pending sentencing.
25,000, Your Honor?
Yes.
You don't think, okay, well, is it too late to move? Can we just move the sentencing in, Your Honor?
You said you weren't ready, sir.
I'm ready, Your Honor. I would rather just go to sentencing than to have to go through this, Your Honor. I mean, if I'm gonna have to be locked up anyways, I told you I'm prepared enough. I've already presented my case. I didn't have much of a case. All I was standing on today was my motion, Your Honor. So once you denied my motion, that motion was my whole case. So without my motion, you've already ruled on my motion. So we've already discussed in writing everything. So at this point in time, Your Honor, let's just move the sentencing. If it's gonna take this much, now, if I would have been able to, if we would have been able to take care of the warrant, then I could get
Okay,
back out and
sir,
prepare.
here's
I'm
my
ready to
question.
proceed. Let's proceed to
Do
sentencing.
you want to proceed to sentencing
Yes,
today?
yes, Your Honor, let's proceed to sentencing. I don't want to be
Are
stuck
you
in jail
ready?
with no bond. Yes, Your Honor, I'm ready.
Is there anything more you want to tell me for purposes of sentencing?
Yes, Your Honor, but I will need my notes back. I just have two more things to say.
Why just say them?
I can't say them without my notes, Your Honor.
Can he have his notes? Can he look at them?
I need my phone, my notes that's in my phone. Did she give you my?
No, I'm not giving you your phone.
Oh, I have my phone. I have my phone, Your Honor. I have my phone. Now that I've been sentenced, Your Honor,
You haven't been sentenced, sir.
I'm ready to go to sentencing, Your Honor. This, what I'm trying to say, that's why I was pulling up my notes, because the last two things I say are part of my sentencing, Your Honor. I thought that when we were talking and you were addressing my motion, I thought that that was all part of sentencing. So I just went straight into my defense, Your Honor. I didn't know that we were going to be addressing different issues. So once you went into my motion, I thought that that was all into one in the sentencing. So that's why I started my defense. I thought that we was already starting the sentencing. So that's why I started to talk about my motion.
You did start, sir.
Yeah.
We're done with the motion. Ms. Madden has made her statement regarding sentencing.
Yes,
I thought you had as well.
I have another statement. I have statements that I want to make, but I was trying to find them on my phone.
Let me hear your statements regarding sentencing.
Okay, hold on, I'm pulling up my statement. Now I had to go all the way back to my records because of the confusion and everything that was going on. I lost all my place on my stuff. So just like has everything that I said, Your Honor, is that already on the record for sentencing? So it's already on record that I want the public defender to take over my case once I'm into custody and everything, correct?
You've already said that, and we're not there yet.
That's what I was saying. That's what
Okay,
I'm,
so-
okay.
Sir,
Oh, yes, ma'am.
statements regarding your sentencing. We'll get to the appeal in a moment. We have to take it one step at a time.
Okay,
You
Your
have to
Honor.
be sentenced first. So is there anything that you would like to say regarding your sentencing?
You're gonna be mad at me, Your Honor. So if I haven't been sentenced, Your Honor, how can we argue my bond yet? How can we argue my appellate bond if I haven't been sentenced?
You're not being punished for your hardships. You're being punished for possessing cocaine and being a felon in possession of a firearm, whether it was in your hand or not.
I'm going to give you one last chance. Is there anything you would like to say regarding your sentencing?
I think I understand. think I now understand. Your Honor, and I have another statement, Your Honor, but I have to find my other statement. And I just said it to you a second ago, and now I can't find it because I thought we were to that point in the court.
Obviously, the record in this case, the court has heard the jury trial. I think I need to clarify, I think that we may have addressed this on the record on November 11 when we clarified the counts. The PSI says convictions for counts 1 and 3. We previously clarified the conviction was for the lesser included of count 2, the DF4, and then the special offender DF1 as charged in count 1. So those are corrections to the PSI. So really, I'm sentencing on count 1, the DF1, and count 2, the DF4, correct?
Correct.
I think, and you can correct me if I'm wrong, or anyone can, but I think the count 2 needs to merge into count 1, and there's a single sentence.
It does. The DF1 count 1 acts more as a sentence enhancer than anything else,
Okay.
but it's weird in the law.
All right, the court will order that count 2, the DF4 lesser included, is merged into count 1. The sentence will be on count 1, the DF1. The sentencing range on that DF1 is between 8 and 32 years, Department of Corrections, to be followed by 3 years of mandatory parole and a possible fine of between $5,000 and $1 million. The court has considered, again, the contents of the PSI, the facts as the court heard during the trial, the statements by counsels today, and Mr. Quick today. As a preliminary matter, I'm not entirely sure I was tracking Mr. Quick's arguments. Mr. Quick, to clarify, you're not being sentenced because of a prior marijuana offense. You're being sentenced because the jury's findings in this case, for your conduct in this case, as it was charged, which includes possession of cocaine and a firearm, not marijuana. So that's what I'm sentencing you on.
Mhm.
To the extent that you perhaps were asserting there's a constitutional infirmity with the DF1 sentencing scheme or the statutes, I'm denying, you haven't made a sufficient argument for me to find that those statutes are unconstitutional.
Mhm.
Those challenges are denied. To the extent that you're asserting something to do with federal court and perhaps some discretionary sentence options in federal court, I don't know exactly what those are, but they're not applicable here. Your conviction is in state court. The conviction for the drug felony 1 in this circumstance is a mandatory Department of Corrections sentence. The court has no discretion. The only discretion the court has is between a sentence of 8 and 32 years. As I indicated previously when I addressed your request for an appeal bond, this is your 4th felony conviction on a mandatory sentence involving possession of a firearm and controlled substances. One of your prior felony convictions was for an attempted second-degree assault. That was from 2002. The other 2 are 2009 and 2014 respectively. Both are nonviolent offenses and don't involve firearms. I find that somewhat mitigating, notwithstanding the fact that they are, in fact, prior felony convictions. The court has considered all of the sentencing factors that are enumerated in 18.1, 102.5.
I still object for the record, Your Honor. Under the, once again, like I said, I'm not a flight risk. I
Sir,
don't pose a
sir,
threat to the community.
You've made your record. You don't need to do it repeatedly.
Yes, ma'am.
It's been made,
Okay.
okay? I've considered the sentencing factors in Mr. Quick's record as a whole, again, considering the nature and circumstances of the case as presented and giving respect to the jury trials, the jury's verdicts and findings. The court finds and agrees with the people that the minimum Department of Corrections sentence is fair and appropriate in this case. Accordingly, on count 1, Mr. Quick, you're sentenced to 8 years Department of Corrections, to be followed by 3 years of mandatory parole.
Yeah, now you're getting it. What you still don't seem to understand is that this is exactly what you've been doing the entire time, which is why every single one of your motions keeps getting denied by the judge. At this point, if he can maintain even this level of cognitive function, we might actually get through sentencing sometime this century.
All right, Mr. Quick, as to the issue regarding appeal, you will be incarcerated, so you do automatically qualify for the appointment of the Office of the Public Defender to represent you on your appeal. Are you asking that the court appoint the Office of the Public Defender to represent you?
Yes, I'm asking that the court appoint the public defender to represent me on my appellate case as long as I'm in custody.
All right, sir, I will so order that. I'll get a written order issued appointing the Office of the Public Defender for purposes of appeal. I'll make a finding that you may proceed in forma pauperis, which will allow the Office of the Public Defender to proceed without appeal without payment of costs. There's 49 days, sir, for you to file that notice of appeal and otherwise docket it. By appointing counsel, I would expect that your counsel will do that, and they are certainly aware of that limitation.
My counsel will be taken over from the progress because it would already be filed.
Additionally, sir, you have the right to seek or request reconsideration of the sentence. A motion pursuant to Rule 35B must be filed within 126 days from today if no appeal is sought. If an appeal is sought, it's 126 days or 18 weeks after your conviction is otherwise affirmed, if that is in fact what happens. I'm also going to notify you, sir, that you may spend less time incarcerated than the term that I have announced here. The actual time served will be influenced by a number of factors, including but not limited to your previous criminal activities, eligibility for earned time, for good time, your correctional education program earned time. It will be reduced by that credit for time served, and there's also a consideration it may be reduced pursuant to your community corrections eligibility. Is there anything further from the people?
Nothing further.
Anything further, Mr. Quick?
Nothing further.
Okay, I'm going to vacate the warrant. You're remanded to serve that 8-year Department of Corrections sentence.
And Your Honor, when the order granting the motion to proceed in forma pauperis is filed, can we just get it sent to either myself or Ms. Roisman so that we can file the appellate packet, please?
Yes, and for the record, that was Ms. Paloma Calipo with the Public Defender's Office. I'll send it to you and Ms. Roisman for your
This stuff right
request.
here,
Thank
give
you.
it to my cousin.
Okay. All right, thank you, Ms. Hermosillo. We're concluded.
Yeah. I'm going to set it off to the side so she can call another case.
Thank you. Have a nice day.
Got both your papers, bro. File them both now, bro.
Ms. Madden, do you want to take these back?
Yes.
Okay, thank you.
Hear what the public defender says, bro. Y'all, yeah, that goes to my cousin.
All of it?
All of it. Everything right there goes to my cousin.
He said all of this.
File it, bro.
He didn't really take anything in. He just sat there asking for a public defender to handle his appeal, then immediately turned around and told his cousin to ignore the public defender and file the appeal himself. Not exactly a solid strategy. Maybe that's because his cousin is named Benny. Who knows? Anyway, that's going to wrap up today's video. If you enjoyed it, hit the like button. If you didn't, hit the dislike. Either way, drop a comment down below and make sure you subscribe with notifications turned on so you don't miss any of the upcoming content.